Court is in session in cause number 327-904. The case is style of state of Texas versus Derek D. Thomas or Derek DeMond Thomas. Mr. Thomas, is that your full name?
Yes, sir.
How are you doing, Mr. Thomas?
I'm doing okay, sir. Woke up this morning.
Okay, yeah, it's a good thing to wake up. Mr. Thomas, I see here that the last time we were here in court, you stated that you wanted to hire your own attorney.
Yes, sir. I still ain't have.
You're gonna have to speak up. She's taking a record.
I'm sorry, man. I still ain't have one yet, sir.
Okay, how much time do you need to hire your attorney?
Need a little bit more time. Sir.
Okay, a little bit is how much? 30 days, 45 days?
45 days.
Okay. Let's reset Mr. Thomas for 45 days. Give an opportunity to hire his attorney.
I'm sorry, I talk low.
I understand, that's what I'm saying. You're gonna have to speak up because she's taking a record. That's reset to when? Okay, your case is gonna be reset to April 1st of 2022. Mr. Thomas, you're gonna stand on the 4X in front of our court coordinator. She's gonna reset your case. Once you reset your case, you'll be free to go and you have a blessed day. All right. Okay,
Just out there.
okay. That was, Burbank. McIntosh. Okay. What you see is Ms. Nelson is out there, so before we start this here. Court is in session in cause number 327-594. Case is style of state of Texas versus Abriana Monique Nelson. Ms. Nelson, is that your full name?
Yes, sir.
How you doing, Ms. Nelson?
All right, how you doing?
I'm doing fine. Ms. Nelson, see here, the last time that you was here, you stated to the court that you wanted to hire an attorney, is that correct?
Yes, sir, but I changed my mind.
Okay, now, Ms. Nelson, you said you changed your mind. Now you have three options in reference to having an attorney to represent you. Number one, you may hire an attorney. Do you understand that?
Yes, sir.
Number two, if you do not have enough money to hire an attorney, you may request an attorney to be represented, to be appointed to represent you. Do you understand that?
Yes, sir.
Or number three, you may represent yourself. Now, do you understand that?
Yes, sir.
If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time, and you may request counsel from the court. Now, the form that you will be given out has, the form has, let's see, 5 choices. Now, at the bottom of that form, if you want to reset your case to hire an attorney, you put your initials on the first line to the left. If you've already hired an attorney, you put your initials on the second line to the left and the name of the attorney in the line to the right. If you want to have an attorney appointed to represent you, then you will put your initials on the second line, excuse me, on the third line to the left. If you've already been appointed a court-appointed attorney, then you put your initials on the fourth line to the left and the name of the attorney line to the right. If you desire to have, well, to waive your right to an attorney to represent yourself, then you put your initials on the fifth line to the left. And then once you finish initialing one of those lines, you'll sign it at the bottom of the document where it says defendant, and you place today's date, this February 11th of 2022. Do you understand?
Yes, sir.
Okay. Could you give her a form? I know you had filled out one before. You could take a seat and he'll get a form to you. All right, you're welcome. We're in session in cause number 327156. The case is styled the state of Texas versus Kathleen Elizabeth Mobley. Ms. Mobley, is that your full name?
Yes.
Yes. Ms. Mobley, how are you doing?
I'm doing good. How are you? Your
I'm doing fine. Thanks for asking. Ms. Mobley, you are here represented by your attorney, Mr. Ryan Matuska. Attorney Matuska is appearing via Zoom. Attorney Matuska, how are you doing?
Good morning, Your Honor. How are you?
I'm doing fine. Attorney Matuska, Ms. Mobley's case is on the court's announcement docket. What is your announcement in this case?
Yes, Your Honor. We're still conducting discovery on this case, Your Honor, and we would ask for maybe a 30-day reset so we can get her all the information she needs to come to my office and view it all.
Okay, Ms. Mobley, your case will be reset to March 11th of 2022. You can stand on the far X in front of our coordinator. She will give you a reset. Once you get your reset, you'll be free to go and you have a blessed day.
Thank you.
You're welcome. And Mr. Matuska, your reset will be sent to you. I think this is your only case. You're free to go as well and you have a blessed day.
Sir, Your Honor, have a good weekend.
You're welcome. Ms. Nelson, Adriana Nelson, come back. Okay, so she has to, she need to have, fill out a financial, yeah, she can go ahead and have her receipt. It's gonna take time to fill it out. Mm. Just don't know. Let's see, that's her. Monthly. Court is in session and cause number 330126. Case is style of State of Texas versus Nicholas Caleb Davis. We have Mr. Davis who is present. Mr. Davis, is your full name Nicholas Caleb Davis?
Yes, sir.
How you doing, Mr. Davis?
I'm all right.
That's good. Mr. Davis, you're here represented by your attorney Jack Lawrence. Attorney Lawrence, how are you doing?
Just fine, man.
That's good. State is represented by Attorney Blake Ham. Attorney Ham, how are you doing?
Very well, thank you, Your Honor.
Let's see, this is cause number 330126. Case of style of State of Texas versus Nicholas Caleb Davies. Mr. Davies is represented by Attorney Jack Lawrence. Attorney Lawrence has filed a motion in this case that is titled Defendant's Motion to Dismiss or alternatively to set aside the information. Okay, so Mr. Okay, okay, State, you have a copy of the motion. I have a copy of the motion as well.
Yes, Your Honor, state has a copy.
Okay, Mr. Lawrence, are you ready to proceed?
Yes, Your Honor. And it's very simple. The alleged victim filed an affidavit, she signed an affidavit, which is attached as Exhibit A. She does not want to proceed further with the prosecution and wants us to dismiss it. And I assume she's not going to be a witness in the case anymore from her affidavit. She's wanting things to go on and everybody proceed with their lives. The parties, the complainant and the defendant were like a boyfriend, girlfriend. And that's probably why it's filed the way it is, to be honest, but it's pretty obvious that the complaining witness is not going to show up. So if you were to set the case for trial, very likely the state would not have much of a case to go forward with. So we just would ask the court to dismiss it based on the fact she's revoking her allegations with her affidavit, her sworn affidavit, to not proceed further in the case. I do not know if she's taken the class yet. The last time I checked, I haven't spoken with her again since back when we were coming to court on this before, some time ago, half a year ago. But I had, back then, Julie Maxey was in charge of the case, and she had said that she, in order for them to dismiss, she would have to take the options class. I haven't spoken to the complainant since then, and as far as I know, I don't know whether or not she's taken the options class yet or not. I guess based on what has happened so far, I'm just unaware of whether or not she took the options class. But she hadn't the last time we were here. So that's all I know on that. I think it would be the right thing to do would be just to go ahead and dismiss it since she's not going to prosecute.
State, Mr. Ham?
Yes, Your Honor. The state requests that the court deny the defense motion for at least 3 reasons. Number one, Texas Code of Criminal Procedure 27.02 identifies the types of motions available to defendants in these situations. This is not one of those listed. The Court of Criminal Appeals in State v. Johnson, number 2, explained that trial court may dismiss a charging instrument for various reasons, including defect in form or substance, denial of a right to a speedy trial, or prosecutorial misconduct. None of those things are an issue here. And finally, this is the state's case. And even if the victim in this case wants to dismiss, once the charge is dismissed, it's not up to her. It's up to the state. So for those reasons, and the state wishes to proceed at this time, therefore, for those 3 reasons, the state requests that the court deny the motion.
Well, Your Honor, just in reply, it's just a simple matter of due process that the state has to have a complaining witness if they're going to, I mean, if we go to trial, the state has to have a complaining witness to go forward. And I have heard of the state proceeding by itself before. I've heard of that happening, but in this type of case, there's not going to be a fact witness, to my knowledge, as to what actually happened. And it would just be a waste of time. But without a complaining witness, and like I say, the last attorney that I had any contact with on this was Miss Maxey, which was some time ago. So I really don't think the state has much of a position to proceed on. And what will happen is, this has happened before when Judge Flores was here. The state goes ahead and tries to set the case for trial, and then they don't have a fact witness. I mean, so then whenever we get to trial, it's a lot of work for nothing. But when we get to trial, I just move for judgment because the only fact witness is my client. I mean, I've heard these arguments before, but they don't seem to go very far, and it doesn't. The legal reasons that he cites, this isn't a basis for dismissal that's included in the statute. Well, that's completely knocked out by what my client's due process rights are under the situation. For my client's constitutional due process rights under the 14th Amendment and the 6th Amendment to the right to a fair trial. So I just, I think the court should look at this as a more or less a demurrer by the complaining witness. That's basically what you have.
Okay. Mr. Ham?
Nothing further, Your Honor.
Okay. The court, well, first of all, Mr. Lawrence, I know you stated the due process. You have any statutes or case law to support your position?
The right to a fair trial under the 6th and 14th Amendment.
Okay.
basic, and then also, yes, I do know that there are cases that require an active controversy to be there in order for the state to be able to proceed. I do know there are cases on that. I'm forgetting what the doctrine is right now, but they do have to have an a viable active controversy, and at present, there's no controversy there.
You saying, okay, you saying that there's no controversy?
With the complaining witness withdrawing her basically filing another affidavit that says she drops the charges.
So you're saying that in every case, every criminal case, a complaining witness only has to come in with an affidavit, said, I want to drop your charges, and the case will be dismissed?
I won't say that happens in every case, but whenever it's as thorough as her affidavit, she goes into details.
Do you have a case law to support or a statute to support your position?
I'm trying to think. I cannot cite you to case law, but I will cite you to his right to a fair trial under
Okay,
the 6th and 14th Amendments.
And just to make the record clear, his case today is not set for trial, is that correct?
Not set for trial at present,
Right, so this is not a trial.
yes.
So, okay,
I can let me read from her affidavit just a little bit, Your Honor, if you don't mind. She does say in her affidavit, I have not been offered any bribe or any benefit. No one has threatened or coerced me in any way. And I understand that, well, skip on down. I am the principal complaining witness against the defendant. I was the alleged victim of the crime. I do not want Nicholas Caleb Davies to be further prosecuted. It is my request that the prosecution be withdrawn, dismissed, and terminated, and I do not want to testify against Nicholas Davies. And no one has promised me anything of benefit or forced me to make this statement. I make it of my own free will in a card. Further, I do not want to testify in this cause. Right there it states they don't have a witness. And this was signed on August 21st of last year, Your Honor. I'll just say on Mr. Davies' behalf, Mr. Davies is a single man. He has 3 children to support, and he has to be able to go to work on his job. And he, with what they've offered so far, he would that would be threatened a little bit. So just on those grounds, I don't think you can have just a blanket. Well, the state has taken a position, even though there's nothing supporting its position anymore. I don't see how that amounts to anything. So as a matter of due process, I don't think that the state has any basis to be able to go to trial in this case. And therefore, as a matter of due process, 6th and 14th Amendment process, right to a fair trial, and as well as the Texas Constitution and the right to due course of law under the Texas Constitution, his case should be dismissed.
And what case do you have to support your position on statute?
Well, it's there's a part of the Texas Constitution that you don't accept, that the pleadings and things don't speak for themselves. They don't constitute a witness. So, I mean, there is a part of, I can't remember. If
This is not
Article
a,
1, Section 11 or Article 1, Section 13.
yeah, but this is not a trial. I mean, we're saying that the pleadings is only a allegation. We know that, but this is not a trial. So that, I guess, the part of the Texas Constitution that you're referring to speaks to the allegation being used as a witness. And so this is not the same thing. Now, the state has cited cases and statutes to support their position.
Well, that's what I'm saying, Your Honor. I'm referring to the due process clause and the right to a fair trial, 6th and 14th Amendments of the U.S. Constitution, plus Article 1, Section 10, Article 1, Section 11, and Article 1, Section 13 of the Texas Constitution.
And what does it say?
This simply relates to due course of law, basically. I don't think you can go forward I don't think the courts can go forward whenever there's no allegation on the other side. I don't think the courts can go forward when there's absolutely no allegation, still no substantial allegation. I'll put it that way, no substantive allegation on the other side. I don't think the
Okay.
Yeah,
state
brief
can go
response.
forward like that.
Yes, Mr. Ham.
Your Honor, to this point, the charges are supported by the probable cause affidavit contained in the file, which defense has access to, and we request the court take judicial notice of the same.
Okay, court will take.
Has it been admitted as an exhibit?
It is, it's in the court's file. He asked the court to take judicial notice, and the court will take judicial notice of the court's file.
All right, if that's the case, then I would like to point something out in the affidavit. And this is the affidavit by the complainant?
He was talking about the probable cause affidavit that supports the information.
All right, let me see. She states that she does not have complete memory in her, she states to the officer that she does not have complete memory of everything that happened. But plus the fact that she had been intoxicated at the time it happened. Apparently, the defendant and the complainant had been dating for quite a while and might have been semi-engaged. I don't know. Were y'all semi-engaged? Or
Semi-engaged.
not at the time? Okay. And anyway, in the police report, which is the probable cause affidavit, I think, she doesn't have memory for a lot of what happened. She states that to the police. And apparently this is a result of her drinking, and
Well,
apparently he was drinking along with her at the time.
basically, that will go to her credibility.
Well, the affidavit may not be that reliable. It's
I'm saying that go to her credibility once she takes the witness stand.
so what the position you're taking, Your Honor, is that the police can bring charges without a complainant, is basically what you would be saying.
I'm saying I'm saying I'm following the law. We have a information that is supported by a probable cause affidavit. That's, well, we have a probable cause affidavit and a valid complaint that supports the information. That's what the law is. And I'm gonna follow what the law is, but in reference, you're kind of getting away from the motion that you filed, which does not have any case law to support it. State has supported this position at this time. The court is going to take this matter under advisement and set this case for trial.
I have something that the prosecution, email that the prosecution sent me in this case, which I would like to admit is an exhibit. And this, if I can, and it's my first chance to show the opposing attorney the letter that Julie Maxey sent me.
Your Honor, the state would object to entry of exhibits in this because this is not an evidentiary issue. It's a legal issue.
Well, Your Honor, it is because it is an evidentiary matter where the prosecution's concerned.
In addition,
Because and this is a prosecutor's statement.
in addition, the email is hearsay.
Objection sustained.
Well, Your Honor, then I would still tender the affidavit as an exhibit, and you may, as our exhibit number 1, I don't have an exhibit sticker. And thank you.
If I'm not mistaken, the state has objected to the exhibit and the court has sustained the objection.
Well, this
So
will
it's
be
not-
part of the record, Your
It's
Honor.
not admitted.
No, I'm taking exception to the ruling of the court. This needs to be in the record, Your Honor. So if you want to look at it before you
Well,
rule on it,
I'm not looking at an exhibit that has not been admitted into evidence.
well, Your Honor, I believe it has to be made part of the record if you rule on it.
Well, I'm saying it's an exhibit. It's offered, it was objected to, and the objection was sustained, so it's not admitted into evidence. So it's not part of the evidence.
I believe it has to be in there as an exhibit, even though you overruled it.
Okay, well,
If you could make it part of the record, Your Honor.
I'm not looking at the, at this here. I tell you, as part of the court's ruling, the court has ruled that the court is taking this matter under advisement, and this case is gonna be set for trial. We give you, we'll set it for trial.
Well, if you would please make this part of the
Okay,
record.
if you're gonna give it to him, you give it to the court reporter, not to the court.
Oh, yes, all right. Could you?
But that's an exhibit that has not been admitted into evidence.
Yes, but that was your ruling that it would not be admitted.
It's not admitted. It was objected to. He had a proper objection, a valid objection that was sustained by the court.
Mhm.
And the objection was hearsay. So the court is going to take this matter under advisement, going to set it for trial. Give us April 18th.
Or April 25th.
Okay. What date? They say April 18th or the 25th? Which one of those dates is?
Could you set it past the first week of May, Your Honor? Could you set it at the end of May or first of June somewhere?
Okay. Okay,
And-
she's looking for a date.
Well, is that better for you?
Yeah.
In terms of getting fixed at your work so you can come down?
Yes.
Last week of May is a holiday. May 23rd.
May 23rd?
Yes.
Okay, case is being reset for trial, May 23rd. Okay, Mr. Lawrence, you can get your You can sign the pad and get your reset for your client.
Yeah.
Mr. Davis, once you get your reset from your attorney, you'll be free to go and you have a blessed day. Mr. Lawrence, I think this is your only case. You'll be free to go as well and you have a blessed day.
Thank you.
I believe so, it's set for an announcement.
Yeah.
And,
We're in session in cause number 320816. The case is styled the state of Texas versus Shamika Shinette Parker. We have Ms. Parker appearing via Zoom. Ms. Parker, you could take your office. Ms. Parker, how are you doing?
I'm all right. How you doing?
I'm doing fine. Thanks for asking. Ms. Parker, you're here represented by your attorney, Mr. Tom Burbank. Mr. Burbank, how are you doing?
I'm doing fine, Judge.
That's good. Mr. Burbank, what is your announcement in Ms. Parker's case?
Well, seeing that Ms. Parker has advised me I'm not doing my job, we asked that this be placed on the trial docket and set priority because she does live in Dallas or the Dallas area, and it is a hardship for her to come down. I am court appointed. This is a criminal mischief case, which I believe has video of the actual act. And it will be-
Okay, give us a court date. You want a number one setting?
Absolutely, Judge, because I don't want to be accused of not doing my job.
April 18th.
Okay, it's gonna be reset and put it on number one, April 18th.
That would be fine, Judge.
Okay.
And if you
Ms.
can instruct Ms. Parker that prior to that, she needs to call me and make arrangements to be here.
Okay. Now, Ms. Parker, your case is set for trial on, was that April 18th of 2022? You need to be here in person for the trial. You need to talk. I think your attorney wants you to give him a call so you can talk to him about the case prior to the trial. Your attorney will be given a copy of your reset. Stay in contact with your attorney and your bondsman. The bondsman will also be given a copy of your reset. You'll be, this will conclude your case. You're free to go and you have a blessed day.
Thank you. You too.
All right. What you call John Bernard?
He's outside.
Okay, that's the gentleman that had, wow, we didn't have spindle top here today. Okay. Let me do this. Here, hold on a minute. Let me do this here. Let's go on the record. We're on the record in cause number 328902. Case is style of state of Texas versus John Willis Bernard. Mr. Bernard, is that your full name?
Yes, sir, it is.
How you doing, Mr. Bernard?
I'm doing good.
That's good. Now, Mr. Bernard, you're here represented by your attorney, Mr. Tom Burbank. Mr. Burbank, as I mentioned earlier, I see a note that your client, Mr. Bernard, is receiving services from Spindletop Center?
That's correct, Your Honor. And he has provided, and I will provide this to the state as soon as I make copies of his continuing counseling and going to treatment. And I believe Monday he has another court date or another doctor's appointment there. So I would ask at this time that it give him sufficient time possibly to maybe get down the road a little bit, and then we can determine what to do with this charge.
State?
No opposition from the state, Your Honor. The state is happy that Mr. Bernard is continuing his services.
Okay. Yeah, Mr. Bernard, the state well, the court like to commend you for taking the initiative to address your issues.
Yes, sir.
Just continue to participate in those services that are being provided to you by the Spindletop Center. Your attorney is asking for your case to be reset, to give you time to continue to participate, and the court.
Well, I've also completed the battered intervention and prevention program too.
Yep.
'Cause
Oh,
I
that's-
mean, I'm, like I said, I've been in conversation with my doctor or psychiatrist, whatever it is, so he recommends some things, so I've been trying that as well.
Okay, well,
If you need that certificate, I could bring that.
okay, you can provide that to your attorney. Okay,
Take care of it.
well, just continue to participate in the programs and follow the advice of, your doctor and those individuals who are providing the services
Yes, sir.
to you. Is anybody there? Okay, so what we're gonna do,
Set it for about 90 days, maybe, Judge?
okay, do you have any objections, State?
No objection from the state.
Okay. Okay, so we're gonna reset the case for 90 days,
That puts us into May 6th.
May 6th. Okay, the case is gonna be reset to May 6th of 2022. And again, Mr. Bernard, continue to participate in the program. And the court commends you for taking initiative and following through on the things that they are asking you to do in the program, okay?
Yes, sir.
All right, Mr. Burbank, I think this will conclude your case.
That'd be excused to the
Yes,
date.
you could get your sign for his reset. Once you get your reset, Mr. Bernard, you'll be free to go. You have a blessed day, and you have a blessed day as well, Mr. Burbank. Okay. I know,
Used to sign them checks on file.
got one small glove and one large. Got one small.
I'll get you something back.
Okay. Miss Nelson, Adriana Nelson, cause number 327-596, excuse me, 594. 327-594. Okay, you automatic qualify. Okay. Ms. Nelson, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes, sir.
Second document is Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On the second page of your Affidavit of Indigence, there's a signature above the line that is titled Defendant Signature. Is that your signature?
Yes, sir.
Ms. Nelson, prior to signing and initialing these documents that I've just read, or that I've just shown to you, did you have an opportunity and did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Nelson, I've read your, I gotta get the. Miss Trina, did you get my? Okay, Ms. Nelson, as I said, if you meet the eligibility requirements for the appointment of a court-appointed attorney, and your attorney that will be appointed to represent you in this case is Attorney Terrence Allison. And okay, Ms. Nelson? Yes,
I'm sorry, Your Honor. Rather than a normal 30-day reset, would you mind making it a 60-day reset? We've already had some communications on how she can
Okay.
complete.
okay, would, okay, just reset it for 60 days.
April 8th.
It's gonna be reset to April 8th, 2022.
Yes.
Okay, Ms. Nelson, you can stand on the 4X in front of our court coordinator. She's gonna give you a reset. Once you get your reset, you'll be free to go, and you have a blessed day. And you have a blessed day, Mr. Gilliam.
Thank you, son. Have a nice.
All right. Thank you. Court is in session in cause number 331040. The case is filed the state of Texas versus Willie James Drew. We have Mr. Drew present in court. Mr. Drew, is that your full name?
Yes, sir.
How you doing, Mr. Drew? Okay, Mr. Drew, you're here represented by your attorney, Attorney Bruce Cobb. Attorney Cobb, how are you doing?
I'm doing fine, Your Honor.
That's good. State is represented by Attorney Daniel Boyd. Attorney Boyd, how are you doing?
Doing well, Your Honor. Thanks for asking.
That's good. Now, Mr. Drew, I have before me an information that was filed by the District Attorney's Office. This information alleges that on or about July 24th of 2020, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Drew, do you understand what you have been charged with?
Sir.
And to this charge, Mr. Drew, how do you plead? Guilty, not guilty, or no contest? No contest? Now, are you pleading no contest freely and voluntarily? You have to speak up. She's taking a record.
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
I wish to file a contest.
Okay. Mr. Drew, I have another document before me. This document is titled Misdemeanor Plea Admonishments. It is also labeled as State's Exhibit Number 1. Mr. Drew, do you recognize this document? Could you could step right here. Do you recognize this document? Okay, you have to say, yes or no. Now, she can't take, Okay. Now, on page 2 of this same document, there's a set of initials.
Yes, sir.
Are these your initials on the line next to a box that's checked nolla contendere, which means no contest?
Yes, sir.
And on the next on the same document, but the next page, there's a signature above the line that's titled Defendant. Is that your signature?
Yes, sir.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, I have before me, do you recognize this document?
Yes, sir.
Is this your signature above the line that is titled Defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
You have the discovery certification.
Yes, sure, I do.
Mr. Drew, I have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Drew, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment. You'd like to offer State's Exhibit Number 1 and State's Exhibit Number 2,
Yes,
the probable cause affidavit. Any objections, Mr. Cobb?
No objections. Your
No
Honor.
objections. State's Exhibits 1 and 2 are admitted. Mr. Cobb, you have advised and counseled Mr. Drew. Is there any evidence that he is currently mentally incompetent to stand trial?
No evidence, Your Honor. He's fine.
Mr. Drew, your attorney, Mr. Cobb, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Drew, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's 180 days jail, probated over 18 months, $200 fine, 60 hours community service, DWI education course, drug and alcohol assessment. And this cause number will run concurrently with cause number 21-36203.
Mr. Drew,
Sir.
the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not have to serve any time in jail for this case because you'll be placed on probation for 18 months. During the 18-month probationary period, you will be required to pay a fine of 200. Yeah, no, I'm thinking about something else. Is he already on probation?
Yes, Your Honor. He's on felony probation at 21-3.
Okay, how long will you be on probation?
Yeah, 4 years now.
Okay, so I need to, I'm gonna explain something to you. Let me do this here again. Okay, so now, Mr. Drew, the state is offering that you serve 180 days in jail, but you would not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 18 months. During the 18-month probationary period, you'll be required to pay a fine of $200 plus court costs of $422, which comes to a total of $622. You'll also be required to pay, here it says a probation fee of $60. Now that probation fee, because you're already on probation, you will not be required to pay the probation fee on this case. Now, his probation is in this county?
Yes, sir.
Yes, Your Honor.
Okay. And so you'll be required to pay a urinalysis fee of $15 each month. You will be required to reimburse Jefferson County for the court-appointed attorney's fees of $250. And you'll be required to pay a DWI, Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, the total monthly installments that includes $60 probation fee is $130 a month. Now, once they subtract out the $60, once they realize that you're already on probation, this 130 is going to be reduced by 60, so you'll probably be paying about $70 a month. Do you understand that?
Yes, sir.
Will you be able to pay, say, the 130 each month?
Yes, sir.
Okay, so, but bear in mind that they're probably going to reduce it to $70 a month. Now, you'll also be required to perform 60 hours of community service, attend and complete a DWI education class, have a drug and alcohol assessment, and this case will run concurrent with cause number 21-3620. And you will also be required to adhere to the other standard terms and conditions of your probation. Do you understand that?
Yes, sir.
Now, Mr. Drew, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Drew, I will uh, follow the plea bargain agreement that you have entered into with the state. Mr. Drew, you're gonna stand on the X where your attorney is standing. You're gonna follow the directions of our court clerk. And once you finish following her directions, you'll be free to go, and you have a blessed day. You're welcome. Court is in session in cause number 330628. The case is styled the state of Texas versus Lashida Lucille Marshall. Ms. Marshall, is that your full name?
Yes, sir.
How you doing, Ms. Marshall? That's good, Ms. Marshall. You're represented here by your attorney, Attorney Charles McIntosh. Attorney McIntosh is appearing via Zoom. Attorney McIntosh, how are you doing?
I'm doing all right, Judge.
That's good. Attorney McIntosh, what is your announcement in Ms. Marshall's case?
This is our first appearance. I've gotten written discovery, but I have not gotten the videos yet, Judge. So we just asked for a reset.
Give us a date. Okay, this case is going to be reset to March 11 of 2022. Give your attorney an opportunity to get the videos in your case. And Ms. Marshall, you can stand on the X in front of our court coordinator. You can sign for your reset. Once you get your reset, you'll be free to go and you have a blessed day. And Mr. McIntosh, let's see, I think this is your only case.
Yes, Judge, that's correct.
Okay, your reset will be sent to you. You're free to go and you have a blessed day.
Appreciate you, Judge.
You're welcome.